There is no difficulty about the right of two consenting persons to decide to live together, to cohabit, and create their unique idea of home, unconstrained by what others say. This is the sequitur to Puttaswamy and Navtej. Conduct hitherto criminalized is now permissible. The liberative effect of section 377 being read down is that two individuals, regardless of their sexual orientation, are enabled to live together with dignity and also protected from any kind of violence for living and existing together. Therefore, the right to be left alone, the right to exercise choice, right to dignity and live one's life with the person of one's choice is an intrinsic and essential feature of Article 21. Even if we want to, for argument's sake, recognize an entitlement under the Constitution to enter into an abiding cohabitational relationship or union, in our opinion, it cannot follow to a claim for an institution. There are almost intractable difficulties in creating, through judicial orders or diktat, a civil right to marry or a civil union, no less of the kind that is sought by the petitioners. Ordering a social institution or rearranging existing social structures by creating an entirely new kind of parallel framework for queer couples would require conception of an entirely different code, a new universe of rights and obligations. This will entail fashioning a regime of state registration of marriage between queer couples, the conditions for a valid and matrimonial relationship amongst them, spelling out eligibility conditions such as minimum age, relationships which fall within prohibited degrees, grounds for divorce, right to maintenance, alimony, etc. The learned chief, as a result, with due respect, we are unable to agree with the conclusions of the learned Chief Justice with respect to tracing the right to enter into or form unions from the right of freedom of speech and expression, the right to form associations, along with right any other corresponding positive obligation. It is reiterated that all queer couples have the right to relationship and choice of partner, right of cohabitation as an integral part of choice linked to their privacy and dignity. Any further discussion on the rights which consenting partners may exercise is unnecessary. No one has contested that two queer couples have the rights enumerated under Articles 19(1)A, C, and D, or even the right to conscience under Article 25. The elaboration of these rights to say that the exercise of choice to such relationships renders these meaningful and that the state is obligated to recognize a bouquet of entitlements which flow from such abiding relationship of this kind is not called for. We therefore respectfully disagree with that part of the learned Chief Justice's reasoning, which forms the basis for some of the final conclusions and directions recorded in his judgment. Agree with the conclusions of the learned Chief Justice with respect to the inapplicability of the SMA, and we also add certain observations. A gender-neutral interpretation of SMA and its provisions, much like many seemingly progressive aspirations, may not really be equitable at times and can result in women being exposed to unintended vulnerability, especially when genuine attempts are made to achieve a balance in a social order that traditionally was tipped in favor of cis heterosexual men. The purpose of the terms like wife, husband, man, and women in marriage is to protect a socially marginalized demographic of individuals. For instance, women facing violence by their partner have a right to recourse under the Domestic Violence Act, which assures and is meant to assure that the victims are safeguarded and provided relief. In fact, provisions of SMA for alimony maintenance confer rights to women. Likewise, certain grounds of divorce, conviction of husband for bigamy, rape, etc., entitle the wife additional grounds. Other provisions enact separate degrees of prohibited relationships. Section 4C uses the term husband and wife. There are other provisions which deal with which specifically used gendered terms. The general pattern of these provisions, including the specific provisions enabling or entitling women certain benefits and the effect of sections 19 to 21A, is that even if, for argument's sake, it were accepted that section 4 could be read in gender neutral terms, the interplay of other provisions which could apply to such queer couples in such cases would lead to anomalous results, rendering the SMA unworkable. It is important. Now, there's a section that deals with the discriminatory impact on queer couples. It is important to recognize that while the state ipso facto may have no role in the choice of two free-willed individuals to marry, it's characterizing marriage for various collateral and intersectional purposes, such as permanent and binding legal relationships, recognized as such between heterosexual couples only, and no other impacts queer couples adversely. The intention of the state in framing the regulations or laws is to confer benefits to families or individuals who are married. This has the result of adversely impacting the queer couples. By recognizing heterosexual couples union and cohabitation as marriages in various laws and regulations, as in employment or nominations in pension, provident fund, gratuity, life and personal accident insurance policies, for credit, particularly joint loans to both spouses, based on their total earning capacity, for purposes of receiving compensation in the event of fatal accidents, to name a few, and not providing for non-heterosexual couples, results in their exclusion. The individual earned benefits by each partner or both collectively, which would be available to family members, such as employee state insurance benefits in the event of injury of an earning partner, provident fund, compensation, medical benefits, etc., are examples of what the injured or deceased partner, by dint of her or his work, became entitled to, or the members of her family became entitled to. The denial of these and inability of the earning partner in a queer relationship, therefore, has an adverse discriminatory impact. The state may not intend the discrimination or exclusion in the conferment of such benefits or social welfare measure. Yet the framework of these policies expressed in favor of those matrimonial relationships results in denial of entitlements despite the professional abilities and contributions which the individual might make to society. The objective of many of these laws or schemes is to confer or provide entitlements based on individual earning and contribution. For example, Provident Fund is payable due to the employee's personal contribution and status as employee. Similarly, objective entitlement of benefits of employees' state insurance, etc., flow from individual status, work, and effort. Major part of these benefits, or all of them, flow in the event of certain eventualities such as fatal accident or death. The design of these statutes and schemes is to enable both the concerned subscriber or the employee to receive them, or in an unforeseen event such as death, for his dependents to receive them. The restrictive way in which dependent or nominee excludes their enjoyment to the intended beneficiary.